What steps does one have to take in order to change your child's legal residence? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm is a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. When you talk about changing the legal residence of your child, there are those who believe that that's just a function of moving. You just move. You've already got the custody of your child. You've got it worked out. The child primarily resides with you. You want to move, you move. The truth of the matter is, though, that ain't how it works. The court's now involved in your life. The court has to make decisions regarding major changes in your life, particularly if there's objection. If you want to move the child out of the jurisdiction of the court, let's say you've decided you want to relocate to Florida, you got to consider that you may be impeding the visitation rights of the other parent. You just can't change the legal residency of the child willy-nilly. The court has to make a ruling that it's in the child's best interest to do that. Now, I will admit that if you have full custody, legal and physical, that becomes a shorter proceeding. It's almost a pro forma thing where the court would let you do that. But if you have full physical custody, but you share decision-making regarding your kid, don't expect to be able to change that residency so quickly. A motion is going to have to be filed before the court. You're going to have to serve the other side. They're going to get to weigh in on it. You're going to have to show the court that it's in the best interest of the children to make the move. And that doesn't mean you got a better job or you're closer to your parents. It means that the school system is better. Crime rates are down. They'll have a better life there. A lot of their friends and family live there. Everything focused on what's better for the children. If there's a medical issue, maybe there's a better medical environment, therapeutically speaking, for the child over there. You may, for example, have a child who's on the spectrum of autism. Maybe there's more ABA therapy that's available in that state, not available in yours. The point is that all of these things have to be considered and brought to the court's attention again in the way of asking permission and in the way of telling the court, I want this permission. Why? Because it's in the best interest of the minor to make the move. That's what you got to do if you want to move the legal residency of the child. And the court's going to have to rule, yes, it is in your best interest, and yes, we're going to let you move. Expect, though, that there are going to be concessions made. There's going to be some changes in the parenting time. By doing that, and no longer can you have the on-again, off-again type of parenting time, you may lose the whole summer. You may lose huge blocks of time, that the parenting time, the child's got to come back to Michigan because you decide to relocate to Florida. There's going to be concessions. The court allowing you to make that change is a grace. The court doesn't have to do it. And in exchange for that favor, if you will, by the court, expect to pay the price as it relates to either transporting the kids to and from, flying them back and forth. The court may well burden you with that obligation. So you got to be mindful of that going in. If you have any questions about that, reach out, and we'll be glad to help you out.